Good evening, learner colleagues. Good evening. Oh, can you see my slide?
Yes, sir.
Okay. Um, so we're looking at terms of contracts. The last time we looked at the elements of contracts, and if you still remember, we'll talk about the fact that you know every contract commences with an offer, which we were made to understand that it's just a statement or expression of intention, which may be in writing, orally, or by conduct. And so we also added that acceptance must correspond with the terms of an offer. So we see that that is the starting point of generating the terms of an offer. At the time that the offeror would have made a statement with intention to create a binding legal relationship, you know, those terms once accepted, they form part of what becomes of the terms of the contract. So, a contract may have a page, 2 page, 100, and of course, where it is orally, may also have some words that the person would have expressed to the other party, which you know may be construed as a valid contract. Now, but then it's important for us to look at these terms because not all the terms are the same. So we'll look at all these terms, and then not all these terms are the same. You know, there are paragraphs that will contain only the dates. There are paragraphs that will contain address. There are paragraphs that will contain, description of the parties. So many things. Now, but then there are also some terms that are very, very central to it. So, in view of the fact that so many weights are attached to different, words or terms or conditions in the contract, we just have today we have a look at those differences. And so we are beginning with, we have terms, capacity, and so other ones are things that we need to look at. But then, first, let's start with this. Someone should read the first paragraph. Just be sure that we are all together. Someone should read the first paragraph.
If the contrast is oral, it is simply a question of fact and matter of evidence for the parties to establish what they have agreed upon. The words used will be interpreted objectively.
Yes. So, as I said, because the contract can be made in different forms. As I said, it can be orally, it can be in writing, it can also be by conduct. You would have gone to someone's shop, make a request orally for supply of you know items or furnitures in your office. The person would accept it to supply them, or maybe a phone call. Just make a phone call, please. So we need XY furnitures in my new office. The person will come and furnish it without even having any cost to sign any agreement in writing, right? So also we now the first sentence is talking about a situation whereby you know the terms of the contract are in containing oral agreement. Where parties make oral agreement and you were to construe the terms of it, you know, the question is always um, as to whether one can see it when it's in writing. But then in construing whether a term, a statement is a term of contract, you know, it's a question of facts and of course the parties must also prove. Because it's oral, is oral, usually oral statement. One of the common way of proving an oral contract is by oral evidence. That is, if you have someone that was present when those parties were making those, you know, those statements, or anything that you can show that that was what the parties agreed upon. But you could see that there's so many agreements that were entered into orally, so many of them. Like the lady colleagues that are ladies in the house, they go to market every weekend to go and buy provisions in the kitchen. And of course, you will never see them sign an agreement with those women selling vegetables, selling, croaker fish, selling all those things that you buy in the market. You never sign the agreement because if you've been signing by now, your parlor, your kitchen will have so many agreements inside. But it's orally, you know, orally. Even you go to filling stations, there are many things that you go oral, or just orally. Transportation, you never sign an agreement with the transport owner or the BRT. You just enter it, you pay, and you go. So there are many of those things that are done orally. So the question is whether a statement made by the parties is a statement will amount to a term of contract. It has to be, you have to prove it based on the evidence available. And of course, in doing that, the words that I use, are to be construed objectively. That is not subjectively, not in line with the intention of the parties, but what a reasonable person will construe as being what the parties intended. Now, but if the contract is wholly in writing, because there are some contracts that are partially in writing, partially in writing. So if this wholly in writing, the general rule is that the general rule is that so class owner meet out to Dr. Labiton to add you as an admin so that you can control your class. People are making noise in the
Okay,
background.
sir.
Please reach out to Dr. Labiton to add you as admin so that I can mute those people that are making noise in the background. Right? So if it's wholly in writing, the general rule is that parties are confined to the four corners. That is it. That is it. Once an agreement is in writing, a contract is in writing, then you cannot use oral, you know, evidence, oral statement to contradict or add to um, that written agreement, except such oral statement is for purpose of clarification, right? So, what's going on here? Oh my God. Okay. Yeah. So this is important because the point is that not every statement that is made in the course of again is a term of contract. Just the way we talk about the fact that they is what they call invitation to treat. Those preliminary statements that are made before an offer is made, which are not binding. The same thing applies to um, you know applies to when one is trying to understand what is term of contract. So not every statement that's made we construe you know a statement of a term of contract. And where a statement amounts to a term of contract is binding. But where that statement is just a mere representation, it doesn't amount to a term of contract, then of course it's not binding. So, but then because of the narrow, difference between a mere representation, because it's usually from representation, it's when you make representation that can lead to, you know, a term of contract. So, by that point, that a representation will move from just being a mere representative to becoming a term of contract. It's only when you are a lawyer with and trained that you can understand those things. And of course, that's what we're learning here. Because of that thin line between the two of them, there are some tests that are used in determining whether a statement made is a mere representation or is a term of contract. As I said, where it's a term of contract is binding on the parties. But where it is a mere representation, it's not binding on the parties. So how do you now determine it? Whether a contract is made in writing or orally, or partly in writing and partly orally. How do you construe determine the differences? So we have the first test. There are about four tests that are used in determining the difference between whether a statement, between a term whether a statement is a term of contract or it's a mere representation. So a test number one, someone should read it out. Test number one, someone should read it out.
The stage of the transaction in which a statement was made. Statements made long before the contract was concluded may be regarded as a mere representation compared to those made shortly before or during the conclusion of the contract.
Thank you. So you will see that usually, because in contracts, it may take a kind of long period before such contract is consummated. In bigger projects, for instance, you may be on it for sometimes for 4 5 years, pursuing a big project, going for meeting one contract, one meeting to another, trying to secure the job. Even in the some of the contracts that require procurement, for instance, in most cases it's difficult to achieve some of those things within a short possible time. Of course, so you see that in the course of you know negotiating or pursuing that project, where and which contract will be subsequently entered into, so many ex correspondence would have gone through the parties. So the issue is that if statement were made, like let's assume that some contract that you've been on it for past 3 years, and 2 years ago you made statement, or 3 years ago you made a statement, and then the one that you made shortly before the contract was concluded, such statement, whether they are in writing or orally, you know the ones that are made shortly before the conclusion or during the execution of the contract are deemed to be terms of contract, unlike the one that were made many years ago. And of course, there's also the question of even in terms of where, of course, where the statement is in writing and another one is oral, and there's conflict between the two, the written statement will supersede the oral statement. And at the same time, the document itself may have terms that are contradicting. So you have, assuming that you know that contract at page 1 or page 3 have a different statement, then at page 25 there's another statement, which seems to contradict the one at page 3. So the question is, which of them will be accepted? Is it the earlier term or the subsequent one on page 25? So all of those things are usually put into account. And of course, by the rule, is the subsequent one that supersedes the earlier one, because it's deemed that the parties, since the same parties have made a statement at page 3 and the same parties have changed that in page 25, it's deemed that they are the one that have changed their mind subsequently, and so override the one that missed. There are sometimes that they even talk about the issue of where document is typed and also handwritten, and there's conflicts. Which one will you accept? In such cases, also the court have heard that where this one document is typed, another one is handwritten, is the one that's handwritten that is deemed to be the one that's acceptable. I mean, maybe acceptable as a binding document before the party. So there are many of such things that you have to look at. But that's the first test. At what time was that statement made? Was it earlier or subsequent, close to the time that the contract was entered into? So the stage at which a statement is made is very important in determining whether that statement is a term of contract or just a mere representation. That is the test number one. Now, number two is where a contract was later reduced into writing. Any statement not in writing will be deemed to be a mere representation. So you will see that parties would have entered into oral communication, oral, and then of course they decide to reduce that into writing, of course. So the law is saying here very clear that look, where this is the case, oral statement were made, parties reduce that into writing. It's deemed that that statement, which was not contained in writing, is deemed to be a mere representation, and not, you know, not to be a statement or a term of contract, as the case may be. And because the third one is the capacity, the knowledge and capacity of the parties, over the subject matter. So if the subject matter is about, real estate, see that people that have knowledge in real estate will have upper hand. If it's accounting, how to do with auditing, services in that area, those that are into that area will have upper hand. If it's aviation, those that are in that industry will have upper hand. If it's the maritime sector, those that have that will have upper hand. If it's insurance or it is stockbroking, it is brokerage, or it is so just name them. So even in this class, you all know your skills. You know the discipline that you belong to. In addition to being a lawyer, you know that you also belong to so many professions, medical doctors, nurses, and teachers, lecturers. So where a party who made a statement has special skills or knowledge of the subject matter, very important. So and of course, statement made. So you're comparing the two now. Someone that has special knowledge about the subject matter and someone that have less knowledge about the subject matter. Then, of course, deem that the person who is knowledgeable, you know, is the one that the statement that would deem to be a term of contract because of his knowledge in the subject matter, even though that can be negated, by the intention of the party. So as professionals, as businessmen and women, when you are negotiating with someone in a contract, the first thing to know is know the capacity of that person, know the person you are dealing with. Don't just go into negotiation blindly. Always try to know, the person that you are dealing with. Very, very important. Very, very, very important. Because if you're not careful, a contract that you have negotiated, it turns out that look, you have more knowledge in that subject matter than the other party. The law will protect the other party and will not protect you. So when the question arises as to whether what the person says, what the other person that have less knowledge of the subject matter, whether that statement is a statement of amounts to term of contracts, you'll be disadvantaged. So always know who you are going into a contractual relationship with. It's just courtesy. May I know you? All those kind of will help you. In knowing whether the person, the statement from that person will be construed as a term of contract or not. So you can see some of the example given there. Harley and Eddie, the owner of a cow, who said, "Oh, I guarantee the cow. I promise to take it back if she's not good." It was turned to be a condition. Of course, it's also you could see where the the seller of a boat said it was sound, but advised the buyer to have it examined. There are several occasions that, look, in the course of negotiating in the contract, you'll be asked upon. You have the right. You can look at it. Even check it very well. Check it very well. You know, all these common traders that say at the market, all this market for clothing and all of those things. You go to Balogo market, they will give you a clothes. Those of you that usually shop there, give. I would say, I look at it very well. You want to buy a gold watch or whatever you buy from those your people, boutique or jewelries, and the case maybe they will give you that. Look at it very well. Look at, so that giving you, see that you should examine it. Those options there. Now those statements, look at it very well. Look at it. They're not statement they're not terms of contract. They're not. So you just have to but you have to pay attention, because if they ask you to examine it and you not examine it and you pick it, right? Except the implied terms that will help you. Otherwise, you are supposed to, you know, it's supposed to be that you are deemed to buy what you bargain for, since you refuse to examine or look at it critically, even though you were call attention to do so. Now, you also have, as I said, you know, classes of terms of contract based on the weight that you attach to it. Now, you will see that in the contract for construction of a building, for instance, contract for construction of building, or contract for supply of consultant services, or training, you know, as the case may be. So if I awarded a contract to conduct a training for NNPC, for instance, there are some basic things that you need to do there. Aside from getting the venue and getting the facilitators, it could be that there are some there are some you can, as well, those facilitators, you can say, okay, you come and come earlier than, come a day before the day of the training, or come on the day of the training early enough. So it depends on how you put all. But see that's contract for training or NNPC staff. We have so many things in it that the weight that you attach to each of them will differ. So if I'm supposed to come and stay a day before the training will start, and I didn't come and stay the day before, but I come on exactly day and I didn't come late and I still did the training, it's a different thing entirely. If I come the day before the training and I didn't do that training at all, I was not able to do the training at all. You see that the weight that you attach to it will be different. So you have what they call condition warranties and fundamental terms. This also all talked about the kind of weight that you attach to each of these terms. Now, a condition is vital, is fundamental in this. I mean, it's close to being fundamental, because where a condition is even a precedent, the law requires that you must comply with it. Otherwise, the contract will be void, will not be even be. You can set aside it, because that is the main thing. So, as I give an example for the contract for training, you are supposed to come the day before the day the training will start. You didn't come on the day before, but on the very day of training you were there. Now, but where you not even come, you came on the day of the day before it, but on the main day you disappeared, right? They will, repudiate the contract, set aside because of breach of a condition, as the case may be. And then the warranties also, as a term of contract, is minor compared to. So different entirely. Okay, you're supposed to be in class, you came late. It's different from when you don't come at all. So each contract will have terms that they have lightweight, and then there are some that are major. So as lawyers, it's now down on you to find out in your contract which of them are the terms of the contract and which you need to pay attention to, and those are just a minor, such that even if you don't comply with it, the contract will still go on. Because where it's a major one, then you can repudiate or set aside the contract for breach of it. But where it is minor, you may ratify the contract and then just ask for damages, as the case may be. Now, in all of this, you know, fundamental term is above all of them. In the fundamental term is where you depart completely. You depart completely from from what the parties intend that you should do. It could be that they hire you to come and do the training. Then instead of coming yourself, you send someone that is not even don't have any of those things that you need to know about teaching of those ones. Total departure from what you're asked to do. Many ways. Contract for supply of fertilizers. You are to supply 1 million. You 100,000. You supply only 99. 10 bags were missing, as the case may be. The 10 bags, person will look at it as being minor and things like that. But when you don't comply at all, even between you and the rest of Lagos, you know, the same thing will apply. There are sometimes that you can miss the CA, that's continual assessment, but then you may write exam and pass. But if you do the CA alone and you not write exam, it become very fundamental. You cannot pass. So there are some of those things that even the exam, if you come to exam late, you can still write small. If you don't come at all, become a fundamental issue. So what I'm saying is that for every contract you go into, that there are some things that are very germane that if you don't do them, then it will amount to a breach of contract. Remember that what the contract does is to create rights, duties, and obligations for every parties that are in that contract. Right. So that's what the law will look at. What is your obligation in that contract? What's your duty in that contract? Is it a major duty or is it minor? When it says it's minor, it means that even if you don't carry out the obligation, the contract itself they will not be affected. Of course, there will be minor effect, but it won't affect the substance of the contract. But if your obligation is such that if you don't do it, then it will affect the substance of the contract. That is why it will be classified, such areas will classify as being a condition or being a warranty or a fundamental term. So there are two cases there, Pulsar and Spy Pound, and then Bettini case also there. So I will ask, give you 2 minutes, Google that case. Let's Google those two cases. You can Google any of them that attracts you. Take 1 minute, and then I'll ask you to give me your comment about those cases so that we can learn more from it. So 1 minute, I give you 1 minute to Google the cases, anyone at all, and then you can always raise up your hand and just share with us what you read about the case. Yes, yes. So let's listen to someone. Hello. Hello.
Hello, Prof. Good evening.
Yes.
Yes. So I'll speak on the case between Bethany, Bethany and Guy, Frederick Guy, 1876. It was a case of termination of termination of a contract due to performance. So there was a contract held between Alessandro Bettini, who was the opera manager, and Frederick Guy, that he would not sing anywhere within 50 miles of London except at the Royal Opera House from 1st of January to 1st of December. He'll be paid £150 to perform between 30th of March and 13th of July, and that he must be in London without fail 6 days before rehearsals. But Bettini, Alessandro, Alessandro did not show up until 28th of March, which was 2 days as opposed to 6 days. So what happened in court was the provision held that he arriving 6 days before was not a condition that would result to a breach in contract, and so it was not a condition. Probably it was a warranty. I don't know, but based on that, it was not enough for the contract to be terminated, and that if he had put it in clear words, that if he didn't show up, that he would be terminated. It wasn't stated in his contract. That's all I could pick up. There's still more, but it's still long, Sha.
Yeah, yeah. So thank you. Who else want to add to what Her Excellency have said? Any other person? I was out that some people will log in and just keep quiet. They log in and doing some other things. It's like they allow us to make noise, and then they after the class they have attended lecture. So class governor, if I call on someone that's I've logged in here and the person not respond, it means they're not part of us. Then you have to remove that person so that you just have a population that is not working. Yes, kudos.
Good evening, sir.
Good evening, counsel.
Good evening, sir. Good evening, counsel. All right, so I want to also speak on Bethany versus Guy, which is 1876 actually. So Bethany is a singer which entered the contract with Guy and the management of Royal Italian Opera. And they said the contract specified that Bethany should have arrived London 6 days before the commencement of the performance. However, Bethany failed. Uh, so the key issue was whether Bethany failure to arrive for the rehearsal was considered a breach of condition in or warranty. So Guy would be entitled to, if Guy would be entitled to terminate the contract or not, or if it's a warranty. So the court ruled and said the provision regarding the rehearsal was a warranty and not a condition. So therefore, Guy was not entitled to terminate the contract, but could have actually claimed claim damages and maybe any other losses incurred. I'm done, sir.
Okay, thank you so much. So at least you could all see that those that are reading with them, you will all see that even though the contract has so many things to be done, you will see that not the weight attached to those things that to be done and is not the same. And that's the point we're making when it comes to evaluating the terms of contracts. So there are many of such terms as we're going to see. That is one aspect also which I expect you to pay attention, so that it helps you as businessmen and women the weight that you attach to a term of contract helps you so that you avoid situation whereby they sue you for breach of contract, or if on your own side too you have to perform that contract, you know that you should pay attention on things that you must do in line with that contract, and things that even if you don't comply with, nothing fundamental would have happened. I mean, with respect to that, with respect to that contract, very 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 important. So that also take us to another, as I say, yes, we discussed that already in terms of there are, set of rules providing the context in which exclusion clauses will or will not apply. One thing also about terms of contract is that, there's what they call exemption clauses. You know, parties are also exempt liability. So in the case of situation whereby you're supposed to come for rehearsals, so at the time of negotiation, you can always bargain that, look, oh, even if I don't come for rehearsals, you know, that should not be treated as a breach of contract. So you are free, because you know that contract is freely negotiated, except standard form contract, like contract of insurance, for instance, whereby insurance company will just give you a template and then insert your names inside. You know, Other than that, it's supposed to be negotiated. Parties will agree on. But one thing is that, look, oh, you also have right, because contract creates obligations, create burden on parties. You also have the right to limit your burden at the time of negotiation, and that's what they call, exemption clauses or exclusion clauses. Mostly in the you can find that most of it, even in the banking sector, those that work in the bank, you know, if we do a transaction on your app, and it's happened that maybe it was the wrong one, it goes to the wrong person, it was the fraudster, you cannot hold your bankers accountable. But if you instruct your bank to do such on your behalf, and such happen, you know, you know, by the mistake was made by the bankers, the bank will be held, accountable. So there are many exclusion clauses. If you go to banking hall, where there's a contract there, but at the parking slot, you see all cars are parked at owner's risk. They're putting you on notice that, look, oh, yes, you are bringing your money to us, you are coming to a contract with us, but look, oh, the car that you're parking outside there, we are not responsible for it. So you have, luggages, you are traveling, that you want to put your luggages either in the flight or in the bus, as the case may be. You know, the flight owner will put it that there's a clause that's telling, look, all the baggages are owner's risk. If this, so you have to take care of your bags. You know, so there are many of such, exclusion clauses that are there, and just that the parties, those limiting clauses would have been in such a way that the parties will be aware of it at the time they're negotiating, not to go and hide. Even though some banks, most bankers, even when I can't open it, There's a account opening form, where the bankers will print those words, those terms there. They're very tiny, tiny, tiny way that you cannot even read it. you know. But if anything happen now, they will refer you to that account opening form that you fill there. Look at it. The terms are there. When in fact the terms are not readable. So if you are a banker in this class, note that if you are doing that, law is looking at you, because you are supposed to print those words in a manner that the customer will look at them and read them, not to just say sign here, sign here, sign here, because you want to get that, open the account on behalf of that customer and get a promotion, as the case may be, right? So you also have, we're still classifying terms. We also have, what they call implied terms. So you see that in contracts, even though parties are given the free will to negotiate, to bargain for what is of their interest, there's no person that is such superhuman that can conceive everything that will happen in contracts and put it on the table at time of negotiating. So because it's not possible to conceive everything, there are occasions that the law will imply sometimes in the contract, and between parties. So those implied terms are classified as terms implied by cost. Someone should read those things so that we know that we're on the same page. Those three, number one, two, three, yes. Someone should read them so that we know that we're on the same one. We're together.
Terms implied by custom or trade, terms implied by statute, terms implied by the courts.
Okay, so we look at them, but just know that look, this classification is what they call implied term and express term. Implied term, express term. Now, I'll give you a typical example of your admission letters or employment letter. You see that in that employment letter, if you just do one page, those things that you can see, you can read in that letter, those are express terms. But then some terms are also implied there. The laws, the nature of the business you are into, and all of those ones, customs. Professionally, some so we can even call it corporate governance. Professional standards. Those are in accounting. You also have professional standards. Those lawyers in the house, ethics of lawyers. They're all implied when a lawyer is engaging in a transaction, either for himself or herself or for a client, as the case may be. So, but of course, we're saying that express term supersedes the implied term. But then we're focusing on the implied term, which we said implied by custom or trade. Of course, trade also include profession. Almost every profession. If you go to medical, you go to marketing and selling, you go to business administration, you go to accountancy, you go to legal profession, estate. Just think of it: medical practice, pharmacy, nurses, aviation, maritime. So you just think of which one. They all have, their professional way of doing things. And so once you are contracting, once you are dealing in that sector, whether you have included those professional, aspects into a contract or not, they are still implied. Custom, the way of doing things, within the community. If you go to the northern part of the country, where Islamic, religion is predominant, and the culture is also Islamic, even the way you dress to a banking hall is different. Even the way you attend to a customer is different. Even the way you even hire a vehicle to go to office is different because of avoiding a mixture between Muslim and non-Muslim and things like that. Even you can't put a trouser and go to work in some states in Nigeria here, whereas you can put your trousers and go to work. In some states like Lagos states, and nobody will you. But you can't wear trouser and go to some places, even though we're all in the same country. So we see that the custom, all those custom, if they, employ you as a banker, they put you in Zamfara. The way you behave in Zamfara is different from the way you behave in Lagos State because the custom varies. So you may not find those ones in any contract. So any contract that's given to you, where you are to construct a road, if you are into construction, or supply. If you are to do it where the custom demands, even in Lagos State here, you should know what happened now. They went sometime. There are sometimes that say, they are doing one festival. People should by 7 p.m. People should not stay at home again. People should not be in the market again. People should not work. You see that once they announce that, that place become very quiet. Even though you have a shop that is supposed to open your shop till 10 p.m. Once they say by the custom of this place, they're closing shops by 6 p.m., you have to close. You don't have any choice. In market, someone, can watch all those things happen in the marketplaces, which I've just highlighted there for you. And you also have what they call terms implied by statutes. You don't need to go far from understanding this thing. The statutes, that's laws enacted by either National Assembly or laws enacted by the State House of Assembly or local government bylaws. All those laws, they are implied in the context of the subject matter of contract we're involved into. So, University of Lagos, for instance, you are given admission letter. That admission in that admission letter, they did not attach University of Lagos Act to it. They did not attach the dress code of University of Lagos to it. They did not attach, the exam rule regulations to it. They did not attach so many regulations, abuse. All these abuses going on there. University have so many regulations against, abuse, either be it staff or suppliers or students. They did not attach all of those ones. But then you will see that all of them are implied, by reference. So that's why sometimes I just to ask, When you are getting when you got the admission letter, and they would have stated in it that look, it's subject to the University of Lagos Act and other regulations of the university. Who among you care to ask the university to give you the University of Lagos Act and the regulation to read first before you accept your admission? Do you do that? Do you read the University of Lagos Act and all the regulations before you accept your admissions? Is there any person in that class that did that? Nobody. And you are all lawyers. You just got admission letter. Then you jump into paying school fees without reading the regulation that is guiding you and the University of Lagos. Excellency, we also did the same thing. Eh?
We did the implied acceptance.
Implied, what do you mean by implied acceptance? You mean that they give admission? They say that your admission is subject to University of Lagos Act and the rules. You don't even care to look for those rules. You just go and pay school fees, and then we're here celebrating you as lawyers. I beg you, learned colleagues, please next time be patient. So now you are into it. You don't even know whether what you are doing is in line with the rules or not, because you just go and some of you even give Thanksgiving for admission. You just and immediately show the admission letter, you just accept, and next day you are giving Thanksgiving without reading the laws there. Anyway, I'm saying that all of those terms are implied, as the case may be. Now, you can also talk about so the let's not go far. Let's go to in the context of business, for instance, where your businesses, for instance. There's if you look at Sale of Goods Act, section 20 to 15, they imply 10 terms in the contract for sale of goods. And not just sale of goods, but even has the issue of title. When anything you are selling, whether you describe that you are the owner, well, you are the owner of what you are selling or not, they imply that you have title in those goods and you have the right to say that's why you are selling. And if you go, that's why you go to market and you are buying things. You go to supermarket, you are buying things to supermarket. You never have cause to ask those people you are attending, those supermarket attendant, look, I want to see the owner. Okay, this is the owner. I want to verify from you. These goods are in this supermarket. Are you the owner? You say yes. Well, show me the evidence that you are the owner. These are things that you're supposed to be doing. No, you don't do it. Just go there. You pick item, you rush, you pay, you go. You are just demonstrating you are a big lawyer. You have money. You go to a car stand, you just point out that car, that very one there. I want that one. They pick it for you. You don't even care to know. Are you the owner of the car stand? No. Are you show me evidence that you are the one that bought this? Clear this car is your own. You never ask for that one. Or is that you saw a car and do what? Why do you do that? You do that because the law is already implying in that contract of sale of a car that the person selling have a title to sell and he can transfer it to you. All of those ones are. If you are buying goods or services by description, then the services should correspond with the description. So if you go out there and you are saying you are a lawyer, you are a learned colleague, you are a lawyer, you are a lawyer of 2 months at the bar, or I don't know how long I call you at the bar. Is it 3 weeks or 2 weeks? I don't know. But you are a lawyer of 3 weeks at the bar. Then you must perform your services as a lawyer. You can't run back and start telling them, say, "Oh, God, sorry, I made mistake. Appeared somewhere to be a lawyer and then they arrested me." No, go ahead and say you're a lawyer. Act because you describe yourself as a lawyer. Act as a lawyer. Accountancy, all of those ones. So the way you describe as who you are, the way you represent that who you are, that's what it is expected that you should also be. When you bought some things online, they are shining. Those things are looking very shiny. Then when you now brought them home, you bought them online, and when they brought it, you see that now okrika, now something fake that you bought. Some of you have returned many things that you bought online like that because the description did not correspond with what you actually got. So they imply suitability. If we're hiring services or consultancy, you're hiring someone based on for a particular purpose, a particular skills. It means that that person that you hire, must have those skills. Not that when he comes after hiring those skills, he's not stumbling. Oga, 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 oga. No, please, so you have beautiful CVs. You have very beautiful CV. Everything you know in this on this, you are so innovative. You can work with less supervision. They give you one assignment, one you cannot do. You are already quarreling in the offices. It's only me that giving me work. Check your CV. What do you put in your CV? Eh? Oh, merchantability. So something that is new should work as a new thing, right? So there's so many of those things are implied by statute. So all the laws, and that's why they say that ignorance of law is not an excuse. So all the laws are enacted in Nigeria, all the laws are enacted in all the 36 states of the federation, all the laws are enacted by National Assembly. It's presumed that all of you in this class, you know all those laws. Now, if anything happens, you can't say no. When they were enacting this law, I was taking lectures in University of Lagos, so I didn't pay attention. You are your own. So how many of you bother to even find out when you are going to transaction as businessmen and women? How many of you find out, even care to find out some relevant laws that are guiding that particular place that transaction you are going into? But these are things that you need to take care of. Terms implied by court, very important. When you talk about terms implied by court, the court, there's what they call hierarchy of court system, hierarchy of courts. So you start from the magistrate court or area court, then you go to state high court or federal high court or national industrial court. All of them are in the same category. Federal high court, state high court, and national industrial court are in the same category, and some other special courts. Then anything that cannot resolve at the high court, you go to court of appeal. Then, of course, after court of appeal, you can go to Supreme Court. So Supreme Court is a final court in the land. So Supreme Court, once a decision is judgment is passed by the Supreme Court, it binds everybody in this country. So what I mean is that if any person have similar problem, similar case, or similar matter, and is to go to court, then that decision of the Supreme Court is the one that they will use to determine who wins the case. So what also means is that all the judgment of the courts are also implied in our contracts to the extent that such judgment are relevant to subject matter that we are going into. All the judgment of the particular judgment of Supreme Court, which are binding on all the courts in Nigeria, because they serve as precedent that subsequent courts will rely on in passing the judgment. So if we have a similar, matter, they rely on the Supreme Court. So at the same time, if we're going into a contract today, as men and women, businessmen and women, just have in mind that if there's any existing Supreme Court judgment on the area that you're going into, is binding on you, whether you are aware of it or not. So you see that what you could see in the contract as a small document, one page, there are so many laws that are imply into it. There are so many case law that are imply into it. There are so many statutes that already imply into it. Custom apply into it. Professional practices, code of corporate governance are applying to it. International standard are applying to it. In fact, even employment, international best practices in employment are implying to are implying to it. Whether whether your employer in the sector you're working, whether they know about it or not, they are all implied. All of them are terms of the contracts. All of them are terms of the contracts. Yes. So any question? Any question? So if there's no question, then we'll just briefly talk about, yes, I think I've discussed this aspect before. I discussed contractual capacity before, just to reemphasize this aspect. We're talking about the fact that in one of the elements of valid contract is capacity. And then we say that, look, the general rule is that a person is both the human beings and artificial beings. So not just human beings alone that are based in Nigeria. So it's also included artificial beings. So the issue is that every person have the capacity to enter into a valid contract. No, but because some other person will be vulnerable, people don't have the same capacity because it has to be that free way of you know consenting. Some people, we have more um, knowledge and the capacity to bargain more than other ones. So you can't place them all at the same time. So the law seek to provide kind of exceptions to some certain parties that, those exceptions try to protect those parties. In most instances, is in respect of what need to be done before such contracts are binding on them. I will discuss this before, like illiterates. We're not saying that illiterates will not go into a valid contract. No, they can, but that contract must comply with the requirement of the law. And who is an illiterate? It's just that person who cannot read and write in the language of contract. You know. So if the contract is in the English language and those parties they don't read and write in the English language, then they're illiterate. If the contract is in Igbo language and that the parties cannot read and write in Igbo language, they become illiterate, even though they are professors of English language. The same thing with Yoruba and Hausa and Tiba and the rest. So the law is saying, look, this is what you must comply with this provision of the, Lagos State, for instance, have one, and almost all the states have illiterate protection law that you must comply with. And those are the requirements. In Lagos State, you can see those requirements there, one, two, three. Someone can read those, someone should read those requirements.
Write his name. Write his name and
Hello?
address on the document.
That is
Ensure
what
that
the. Mhm. So you start from section 1.
Section 1, Illiterate Protection Law, IPL of the Lagos State obliges a writer of any letter or document on behalf of an illiterate to comply with the following requirements.
Good.
1. Write his name and address on the document. 2. Ensure that prior to the document being signed, it was read over, explained in the language understood by the illiterate person, and number 3, state that he was instructed to write the letter or document and that the letter or document fully and correctly represents his instruction.
Exactly. So these are the requirements. So you will see that we're not saying that illiterate will not go into a contract. They will, but you must comply with this. So you must state if you are the one that writes on the illiterate would have instructed you. So you're writing on behalf of the illiterate, put your name there and your address. So that once they pick that contract, they will know that okay, this was the person that wrote this on behalf of the illiterate. And of course you have to ensure that before the trade will have signed, you have read over, explained in the language that the trade understood. And that's why you see that if we're in court, somebody that were in court this week, you would have observed that there are sometimes that the judge where they bring a witness and that person cannot understand English language, they will not bring interpreter. You know, they have what they call interpreter, professional interpreters, who the judge will appoint. So the judge will speak English. The person will not interpret that English into the language that the 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 parties before the court understood. That's what they do. They deploy the service of interpreters. So and in most cases, there are some interpreters that don't even know anything, or they try to change the narrative. So you could also see that where judges will say, "No, that's not what I say." After when they are trying to narrate or interpret, they will now interpret something wrong. You will see how the judge say, "No, no, no, that's not what I say. What I say is this." They will say it again, so that what is being conveyed to the illiterate is the same, with what the judge also was saying. You see, Ogun State also have the same thing. There, that is Ogun State also have the same thing when dealing with, illiterates, concerning landed property. You know, you must execute it. That is for where it's land. that contract, it means that an illiterate cannot sell land to you in a good state unless that contract is signed in the presence of a magistrate or present of customary court grade A or grade B or a justice of peace. you know. So you can't just buy, land like that, from that is Ogun State. So many other states have the same rules the same way. So always, if as businessmen and women, you are going into a contract with someone, and the person did not understand the language of the contract. But I hope you know that here in Nigeria, the language of law in Nigeria is English language, not our traditional languages, unfortunately. English language is the language of law in Nigeria. So for infants, I said that before, infants, any person below 18 years is an infant. Because the question is whether infants can also make contracts. Yes, but then it has to comply with what the the laws the laws provide for. And of course, if you read the first paragraph there, they're saying that for the purpose of capacity of an infant, yeah, that classify. I said this thing. We discussed all this thing before. I'm just trying to emphasize for those that were not there. Contracts can be classified into contract of necessaries. I say necessaries are those things that are rules that are important in the life of that infant. Such contracts are binding. Where they are not necessary in the life of that infant, they are not binding. And then you have beneficial contract of service. You say it depends on the circumstance of this case. So if like tutorials, for instance, or apprenticeship, you know, all these kind of things, where to enhance the knowledge and skill of their child, they are binding on the child. But then if the parents have already provided all of those for the child, and you are now adding another one, you still you know binding on the child because already such services are already provided for by the child. You know, Contract are avoidable. The child may decide to ratify them when it's adult, and don't have contract that are void. So you see those examples here, contracts of loan where the infant obtain loan from individual finance, you know, you don't grant loans, the law prohibits granting of loan to infants, you know, because you're giving them loan that local when you are now an adult you pay. IOU not accepted because I said necessaries are things without which an individual cannot exist. They are all there. Yeah. So when it comes to capacity in respect of a company, I said that before, and it's very important for us to say it because I said it before with respect to the fact that for companies, the capacity you can see is in the articles and memorandum of the company. Now, I ask this question for those of you that are working in with companies. Have you ever have cause to ask them or to ask in your place of work the memorandum of your company that you're working with? Have you ever asked, there are two major documents that a company will keep: the memorandum, which define the rules of a dealing of that there is company and outsiders, and then you have the articles of association which have contain the rules, the internal rules of that company. The memorandum contain external rules, while the articles of association contain internal rules, meetings, quorum, sharing of dividends, you know, meetings, and how to change some situation, so many things, discipline and all of those things, reporting, all of those ones internally. Now, the memorandum will contain external things, just as address of the company, the shareholders, the directors, the object for which the company is formed, so that any third party dealing with the company should know that this is the kind of thing that you're dealing with. So I was saying that if you go to section 43, sub 1 of company, it clearly reads that every company shall have, shall, for the furtherance of the object or purpose of object, shall have all the power.
Hey, wait, wait. It's not opening. The door is bad. Sorry.
Yeah, no phone.
So are you done now? Okay. So our point I was saying that look, for companies, if you look at section 43, which is there on the screen, it's very clear that look, every company shall have all the powers of a natural person with full capacity. A natural person of full capacity. So any person above 18 years, the powers that that person can do, that same powers is given to a company under section um, 43 sub 1 of the KAMA 2020, Companies and Allied Matters Act 2020. Now, if you look at section 27 also of the Companies and Allied Matters Act 2020, section 27, subsection 1, paragraph C, it states clear that local, a memorandum of the company, a memorandum of association of every company shall state the nature of the business or businesses which the company is authorized to carry on. So you see that is where this comes in. This is where the powers of the company, you must state the nature of the business that the company. And now you remember that we said that look, where the company goes outside what is stated in the memorandum, it becomes ultra vires. That is, you're going beyond the power. That's the meaning of ultra vires. And I expect that by tomorrow, when you go back to office, when you're with your colleagues and they're doing something, just tell your colleagues that what you are doing is ultra vires and stop there. Don't say many things. You can even say and disappear. So that if they don't ask you, they ask you a question now, you don't know what to say, just say it and disappear. But you start any respect in your office. Just test it and see. Just throw this low concept on them one by one. Just look, people are just throw one concept and just for the arm looking. You just be getting respect without even knowing, you know. So I told you about one guy that was trained by, if I don't know whether you've seen the right case, the guy that was trained as a medical doctor, he came back and resigned and used the memorandum of that company to say that they're not supposed to. Do you remember the case like that? I discussed that in this class.
Yes, sir.
Good. And so that is the case that is there. Continental Chemist with Ifekandu. So Ifekandu was one that did that to Continental Chemist after he was trained to and became a medical doctor. He came back and told them, look, Oga, go and check your memorandum. You don't have the powers, So what you've done is beyond the powers, right? So what happened is that some of you were also curious that day. Now to control the harshness, you see that it was very harsh. To control the harshness of it, the law has been reformed now. And you can find out in section 44 of KAMA. The law has been reformed now, and you can find that in section 44 of Companies and Other Matters Act. where someone should read it. Someone should read that. Someone should read the last point, the last part of the slide from the harshness.
The court may award compensation
No, no, no.
for any loss.
Start from the one. The harshness of this ultra vires rule is start from that
Okay.
one.
The harshness of ultravirus rule is mitigated by Section 44, comma, which provides that a company shall not carry out any business not authorized by its memo and shall not exceed the powers. A minority or debenture holder to apply to the court for an injunction to stop an ultravirus transaction. The court may award compensation for any loss or damages that a party may suffer by reason of the setting aside of the transaction.
Exactly. So you see that as this now, a debenture holder, that is a creditor or a minority shareholder, you have the power. When like if you can do now, if some there was a creditor, that means that if Conenda Chemist was owning that, maybe a bank, and the bank knew that the chemist wants to sponsor if you can do the bank would have applied to court to stop the company from training that guy abroad. The same thing with the shareholders. So you see, that is the one. And then also, unlike before, now the courts may award compensation. So you see that unlike before, that if you can just say, you know what, you don't have powers and went away. Now the courts may look at the merits of the case and decide to say that, look, oh yes, you are not, you can, it's beyond the powers, but because they're spending money on you, you have to compensate the company based on what the court says. So all of those things are meant to mitigate the harshness of ultra-virus rules, you know, as was tested or applied in continental chemists with Ifekando. You know, these are good area for exams anyway. One can just ask you something on, the extent to which the law have come out has mitigated the harshness of the ultra-virus rule. Very good place for exam. Then, of course, any question on that? Was that just I just reminded you about that aspect because capacity we treated it before under capacity of contracts. Any question? So they say take someone ultra-virus and run. That's it too. Because they will start asking, what do you mean by ultra-virus? It will become something else. So you just tell him what you are doing is ultra-virus, and you leave it. You guys say you can run. You want to run. You can also run. Good. So you have the one thing that we also look at it today, which is privity of contracts. So when you're talking about privy, to be privy to something is to be part of, to be aware of something, part of, you know. So in the context of law of contracts, when you are saying privy to contract, it means that that contract you are part of it. You are part of the contract, right? So first paragraph, someone should read that first paragraph. First paragraph.
The doctrine of privity of the contract means that only parties of the contract can sue on it. A person who is not a party to a contract cannot sue to enjoy any benefit, nor be subject to any burden under the contract.
Good. So you see that between you and University of Lagos now, you see that even what I'm doing here, I'm not University of Lagos. So I'm just doing this on behalf of the University of Lagos. So the contract that you entered into for your certificate is University of Lagos and you. And so you will see that if anything happened to you now in terms of a certificate or anything, do you know that you cannot get someone that will sue in these admissions It has to do with admission. Why? Because the person is not part to the contract that you sign between you and the University of Lagos. Now, it's also when you want to also sue, except for something that I've done that is personal, but it is what I've done is in line with my functions as a staff of the university. You can only sue University of Lagos. So you see that there are many transactions. How do you know the parties? Is the document itself, that contract itself will know. That's why you can know the parties of the contract. And it starts from the offer. Remember that the offer can be made to one person, can be made to two persons, can be made to the entire world or group of persons, as the case may be. Now we're saying that acceptance must mirror the terms of an offer. So when you are accepting, you accept it as it is. So if you are accepting an offer and you add someone else to it, it means that's a counter offer, right? So what is funny that the parties to the contract even start at the time the offer is made. So whoever the part, I mean, that offer was made, you will always see it. So if you pick a contract that is in writing, for instance, you can always see the names of the parties that are involved. So what the privity of contract is saying, look, only the parties that you can see, only those who are parties to the contract that you can sue and be sued under it. So if you're not part under, you can only, if for instance I perform my obligation and you are supposed to benefit, you can't sue me that you want I should pay you because the law will be, I know, are you privy to this contract? So even if you go back to offices now, stop using the word party. Were you a part of this transaction? All those grammar, you are speaking those ones. You are past that level now. When you go back to offices or to your project, your contract, be discuss instead of saying, are you part of this contract? Say, are you privy? Are you privy to this contract? So just be fond of using this word so that people will respect you more because you are no more ordinary citizens. You are lawyers now. You are learned. You are not educated. You migrated from being educated now. You are not learned because there's a difference between being educated and being learned. You are learned. Others are educated, and let them know too. Let them know. It's very important. Now, but if we insist that for every contract, for every contract, they must be same parties. If also those parties you cannot benefit, then there will be, uncertainties in a commercial setting. So assuming that Her Excellency the class governor, for instance, she has superstore shops in Abuja, Port Harcourt, Kano, Lagos, name them. So what I mean is that for her to sue any person that would have purchased something, an item on credit, the shop scattered across the country, for her to, it means that she would have been in those shop, she will be in those shop personally. So she will close one in Lagos, go and open one, say in Abuja 1 week, close it, go to Kano. You see that market cannot flow that way. Market cannot flow that way. So what do? There are exceptions whereby the law allow parties who are not privy to a contract to also sue or claim benefit under it. So you don't have what they call general rule and exceptions. General rule and exceptions. So the general rule is that only parties to contracts can bring an action to sue or be sued under it because of the doctrine of privity of contracts. But there are exceptions because if we want to apply that doctrine strictly, it will not be possible. So there are exceptions. So you see those exceptions are listed there. Who can read it? Who can read those exceptions? Someone should read those exceptions.
Good evening, sir.
Include agency, insurance, trust, bankers' commercial credit, contracts of charter parties, covenants running with the land, and statutory exceptions.
Thank you so much. So, so this before I come to them, let's pick one case there. Someone should pick one case there we support the general principle. So I want you to pick one case there and then Google it first, and let's just give it as an example of what the general rule was saying. There are two cases there. Price from Eastern, Tweedy was Atkinson, Dunlop Pneumatic Tire Company, and Selfridge Limited. They are all cases. Just choose one, and let's read it before we come to the exceptions. So I'll give you like a few minutes.
Okay, I think I'll pick Tweedle versus Atkinson.
Okay, go ahead.
Okay, so the background to the
Announce
case
your
is
appearance. Announce your appearance, Barrister who?
Barrister Precious Imo.
Of cancer. Okay, that's fine. Let's hear you now.
Okay, so William Tweedle was to marry the daughter of William Guy. In anticipation of the wedding, both fathers, that's both John Tweedle and William Guy, made an arrangement to pay the couple money. William Guy died without paying his agreed sum, so William Tweedle, the groom, sued him and sued Atkinson, the executor of Guy's estate, in order to get the money that he was promised. So the court ruled in favor of Atkinson, stating that William Tweedle could not sue because he was not party to the contract between the two fathers and had not provided any consideration to it.
Good. So they even remember that you must pay something of value before you claim under it. Very, very nice. So we see the issue of privity of contract playing out there. Yeah, who else can read another case? Yes.
Okay, I would like to take Price versus Easton and Barrister Oluyemi.
Senior
So
counsel. That's
okay. Price versus Easton happened in 1833 in the English contract law case. So there was a transaction between Easton and one William Price to do some work for him. Easton engaged William to do work for him. In return, Easton promised to pay a debt he owed the son of William Price. So after the work was completed, the son attempted to enforce this law and the promise that Easton made. And the court, in this case, the key point was privity of contract and party of third party rights. The court affirmed that the son of William was not privy to this contract, that the privity in this case was not extend to him, that the transaction was between Easton and Williams and not his son, so he could not partake in that contract. So the court held that a third party cannot sue on a contract even if they benefit from it, unless they are party to the contract.
Yeah. So we see that those cases are meant to support the general principle, right? So that now takes us to the exceptions. At least that's also, I'm saying this because the beauty of when you say in Nigeria we practice law as it is. So when you are saying the general doctrine of law is that only parties can do X, Y, Z, only parties can bring an action to force any contract, blah blah blah. It means that there's a law somewhere that provides to that effect. That's why you are quoting it. That's why, for purpose of exams, make sure that you cite cases as authority. Don't just say the law is this and you stop there. If you want to get good marks, know the cases that are applicable to some of those things that we're discussing. And also know that the cases that we give you here are not exhaustive. They're just meant for you to go and read. And then, of course, they're not exhaustive at all. You go and read, you understand them more, and it's things like that. So take note that those that want to get good grades in the exams, remember that when you say the law is, or the position of law is like this, give us authority, because law all the laws have sources. So you tell us the source of the law where you know that that's what the law is saying. As we're giving you cases and sections of law in the course of our discussion. Right. So exceptions number one, agency. So Professor Polodokum had discussed the agency with you before. So can someone just lead the class? What did Prof say about law of agency? Can someone lead the class for 1 minute at least? What did you learn about law of agency? Yes, who is leading the class?
Let me try.
Okay.
So I know agency are people, and agency is empowered by business to put. So the agent does not own the business, but he has the capacity to monitor the transactions of the business on behalf of the business. I'm not sure. And they also are mandated to provide to report satisfactory state of the business to the owners.
I think Prof said discuss that in class with you people now. So what did he say?
Okay.
What did Prof say about it? Or do you know how your notes there? You don't have your notes there.
Yeah, good evening, sir.
Yes.
Yeah, this is Barrister Gabriel. So
Okay.
I think what I can remember from what he taught us was that it's just like an agency. An agent law of agency is when somebody act on behalf of another person.
Yeah.
So and has the power to create legal issues, transactions,
Yeah.
and every other thing on behalf of that party that is representing.
Yeah. Okay. So it just to remind because it's very important because so you see that in agency, for instance, you are acting. Imagine, for instance, now, University of Lagos, I'm doing something here between the two of us. I'm the one that will going to mark your exam. So we'll do set exam, you mark, give assignment, you mark, we'll do all of those things. Now, whatever I'm doing now will not bind the University of Lagos. So, so the University of Lagos is a person. You can sue and sue its own name. But then I'm my action now, or action of university management bind the university. So if I give you 70 marks, 70 or 100 in this class, university cannot come and deny it. It's binding on them. If I give you 35, it's still binding on the university. They can't say, you know what, you can't do that. You can't give. So although I'm not giving anybody 35 anyway, I'm just giving that everybody will pass very well. So the point is that in a commercial setting, it's usually impossible for you to do everything yourself. Imagine Dangote Group, for instance. Dangote Group have so many other subsidiary companies. So how can even the family, if you want to distribute the family all around, they can't do it. They can't do it. So it's always agents acting on behalf of others. So but we're saying here, look, once even though the agents, the principal are not party to those contracts. Once anything that is done by the agent, buying the principal. So the principal can sue if the agent supply goods to the third party and third party is not, not paying. The principal can sue the third party and claim the money, even though the contract was between the agent and the third party. So we see that itself is an exception. Insurance companies, one typical example is this liability insurance, motor vehicle insurance, for instance, whereby what do? You insure your car against third party liability. So if your car hits another person's car, if you look at the contract of insurance in your car, that person's car that you hit, the owner of that car is not in that insurance contract that you're having. Yet, that person that you hit his car will go and claim against your own insurance company, you know, because of third party liability insurance policy, right? So you at the same time, you can enter into a contract and transfer the benefit of that insurance to someone else, even though the person will not be a party to that insurance contract. It's still so, right? The same thing, a trust. A trust exists between three persons. That is, the owner of the assets will transfer the assets to another person known as the trustee. The trustee will manage that asset on behalf of the beneficiary, even though the trustee may also be a beneficiary. But you see triangle here. The contract is between the contract for managing these assets is between the owner and the trustee. So some of you that are working in trustee companies, like UAB trustee, General Bank trustees, First Bank trustees, we understand some of what I'm talking about here. People come and give you assets, manage these assets on my behalf. That is the contract that you have. So if you pick that trustee contract, it's just the trustee and the UBA trustee, for example, and the owners of the property. But then the beneficiaries of the proceed of that trust, even though they are not members, they're not parties to the contract between the owners and the trustee, can still sue the trustee and claim whatever is the benefit under it because it is an exception. So we can't raise the issue of the doctrine of privity of contracts in that regard. Bankers' commercial credits, the same thing. Contract of charter parties, the same thing. Covenants running with land, the same thing. In fact, someone was giving an example of, in town planning, by rules of town planning, where a land is located, the government of a state have powers in terms of how the town or cities are developed and things like that. So if you go to some people have land close to the airport, so you see that there's a level of height of building around the airport. Now, the first people that bought that land between the government, when government signed that agreement with them, even if those people are selling it to subsequent owners, you see that that covenant will still run. Once there's a condition, a government restriction in respect of particular land, and that was done, with the first buyer of that land, the subsequent people that will buy that land will still have to observe that same covenant, even though they were not together with the original owner at the time that the government was entering in this covenant with those original owners. And that's why, you cannot just go and, even if you buy a property now, you bring it down. You can't just do what you want to do. You must have to go in line with what the government had agreed with the original owners of the land at the beginning, because there's a covenant that runs all through, in that regard. There are also, implied in terms of statutes, there whereby parties who are not persons who are not parties to the contracts will also have, have given the right to enjoy the benefits from that contract. So you see that one thing very clear, almost everything we're saying, general rule, exception. In terms of capacity, we say everybody have capacity as general rule, but there are exceptions. Doctrine of privity of contract, everybody have, in general, you must be only a party to a contract that can bring an action to sue or claim benefit under it, but there are exceptions. So even in terms of contract, we'll look at all of those ones. So that's the beauty of law anyway. And what I expect that you should be, in the course of your practical dealing, when you are, day-to-day activities as businessmen and women, this thing we're discussing in class, we expect that you pay attention to them. We expect that you pay attention to some of this thing, because that's only where our lectures, our interaction here will have meaning. It should have impact on what to do on in your profession as business men and women, so that, because whatever you do is based on the rules, and of course we're just navigating some of those things for you, so you can open your eyes. That's all. For details of some of those things, you can always engage us further, or read further and get more information on that. But just to highlight and bring them to your attention. So that's all. So any question? This is where we stop for today. Any question? Yeah, someone's hand is up. Dennis.
Yes, sir. Thank you very much.
Dennis of
I
Cancer.
Yes. Thank you. So my question is that SERAP always sues federal government. So out of these exceptions that you listed, I want to know where they are, on what ground in each of these they stand when suing federal government, because they always sue even when it doesn't, even when the case does not concern them, they always sue federal government or they sue people on behalf of other people.
Public
So I
interest.
want to really understand.
Yeah, that
Say
they
again, sir.
use it's called public interest litigation. You know, they
Okay.
are yeah, public interest, their interest, when something affects a group of persons or in public, they can on their own pursue it and get remedy. Then the law allows you know non-governmental, like all these NGOs and all these human rights, the law allow them to someone to take action, even though you are not part of those people that are affected. You can always take it up to protect that group of persons, because if you leave them like that, they cannot. So they call it public interest, litigation. The challenge there is that when you get judgment against government, it's the government that's supposed to enforce the judgment. So this is just what they've been facing. You can obtain the judgment, it's beautiful, but then now who will enforce it? It cannot be NGO, it has to be government. That is what Femi Falana has been crying every day. He will even go to West African courts, get judgment, international court. But when you get it finished, someone has to enforce it in Nigeria. And then, so if Nigeria is not enforcing it, my brother, you only created awareness that something is going on, because that is just where we are.
Okay. So I want to ask now: does this fall under the statutory exemptions?
Yeah, but this is also because those ones are not contract per se. What the customer is they feel, but it's not privity in terms of that one is not different entirely from what we're discussing in terms of contracts.
Okay.
Because remember that contract has to do with all this the offer. When you say contracts, all this offer acceptance, all of those ones must be there. So that's why who are the parties at the time of negotiation. Know who are the parties, and we're saying that what is those people that you can sue or claim any benefit under it. That is the context, and of course, it can be oral, it can be in writing, it can also be by conduct. But then you can always know that this was initially between this person and this person. That's what general was saying, and then you have exceptions that allow someone to come from one side and do it. But in terms of that aspect, there's what they call private law and public law. The litigation we're talking about is public law. Contract is private law. That's what the
Okay.
issue of free will is there. But then when you talk about public law, it's meant to protect the society. You're not looking at interest of private persons anymore. So even if you pursue the public interest against the private interest, the law still allow you, because the law look at it that to preserve the society than to preserve someone and destroy the society. So
Okay.
I don't
Noted.
know whether
Thank you, sir.
I'm making sense of it.
Yeah, you have done justice to it. Thank you.
Welcome, yeah. God's will, those of cancer. Barrister, you want to enter appearance?
Good evening, sir.
Yeah.
Yeah. Please, I want to ask a question bordering on the case studies we have made, because
Which
at the
case study?
point of as in
Which
the
case study? Which case study? Which
we
one?
we have made lots of case studies. So because you say that how we get all these case studies is from judicial precedent. Any judgment passed can be referred to in making similar judgment or whatever case of similitude. So my question borders on this, sir. Peradventure, maybe like if you look at Nigerian state, look at how judiciary normally handles cases. Peradventure, maybe a case is perceived that maybe in a layman's eyes, even among lawyers, that they thought maybe a judge who handled this case maybe was bribed, that this case ought not go like this. But the judge has passed his verdict. And this verdict he has passed has to be a judicial precedent in the future. Is there anything among legal experts, because of the future reference to that case, is there anything they can do to like amend such kind of reference?
Yes. What they can do, yeah. What to do is that you have to revisit the same code.
That's number one, sir. Number two question is that why is it that all the references and the cases we're making here, no one is connected to Nigeria? It's all about international. Does it mean that Nigerians or maybe Africans were not business inclined, or our own legal system is not internationally recognized? Because the names we have researched on Google, it's more of foreign people and foreign people.
Yeah, thank you so much. So the point is that that's for the first one. The first question is that once it's a court passes a judgment, you don't like, if it's lower court, you appeal to the higher court. But if it's if the Supreme Court has passed a judgment, whether it's bribe, whether you call it the bribe or not, it still remains the law. So the one once you one so I mean, I don't know how a judge is bribed. Anyway, I never bribed a judge for once, so I don't know. But the point is that if you don't like the judgment, this is what they call you now. You go on. There's application for revisiting. You ask the court to revisit its own decision, and you give the justification why the court should revisit. So the court may revisit and give a contrary judgment. Remember that in judgment, generally, what they do, there's a panel of, when they say the court, when the matter is submitted to the court, the presiding judge will nominate some judges to sit on it. They call it panel. So whatever is the decision of that panel, they call it the decision of the court. Now, those people may even retire. They are no more judges. Some may even go ask the same court to revisit it. The same court may set another panel to look into the matter, and they may come up with a contrary opinion. That is it. Now, but then there are sometimes that if you ask the court to revisit itself, and what you're asking is just frivolous or just making the court unnecessarily busy, they will fine you. They can even fine you. They find one of the senior advocates about 200 million some was it last year or this year, so about election matter that he lost to one of the governors. His client was governor, lost a matter, and then he asked to go. He went back again. They find the senior advocate 100 million for wrong application for court to revisit for something that he knows that is not possible to do. So you can always ask the court to revisit itself. That's number one. Other than that, it remains the law. Now for what do I call it? Number two question was on what?
It was on a case citations. We don't cite local cases.
Exactly. So what to do is that contract is because those cases are the locus classicus. This is what they call locus classicus. That is the genesis of the principle of law that you are enjoying. So in all common law countries are those countries that were colonized by the British. So their laws becomes our own laws. So even though we are no more colonized, their laws still, the source of those laws still define us. So when you are teaching, you teach the foundation. You teach people the foundation, and then all other laws that we have in Nigeria are only building on those foundations. That's why we use them. Because they're the locus. It's from them that those rules of law generated at common law and then now become the law that we practice in Nigeria today. That's why we cite those cases. And then you said there are one million cases after that in Nigeria. But then the source of all of them is the same cases that we're citing here. That's why we cite it, because they're the locus. That is where from them that those things originated. So you can go on and look for, because we can't give all the cases, but at least we give the ones that are fundamental and tell you that this is where they generated, and then of course subsequent ones. But you see that some of them, if you can do is not a English case now. It's not Nigerian. So you are not entirely correct. Yeah. Any other question? In the absence of any other question, your governor, your excellency, can you move motion for adjournment, and then tell us when the court
Oh,
will sit.
and tell us how.
When is the court going to assist? Are we adjourning?
We are not adjourning. Okay.
No adjournment.
Somebody else
Judge
should
will go for
adjourn, sir.
recess. The judge will go for recess. So I want to go for chambers. I need to rest.
Okay, Her Excellency. So I hereby adjourn today's class. We will meet
Reconvene when?
again. I don't know. We'll convene.
We'll reconvene when?
We'll convene next Thursday, 17th of July at 6 p.m.
The same time, Abi?
Yes, sir.
Okay. So, in the absence of any objection to this motion, it's hereby granted. Right? The class hereby adjourned to next week, Thursday, same time, same venue. Bye for now.
Thank you, sir. Good night.
Court rise.
Court
Thank you,
rise.
sir.
Thank you, sir.
Yes,
Good night,
court
sir.
rise. Yes. I'll take your dinners now. Take your dinner and sleep.